How can I minimize the chances of my will being contested after my death? Well, the first thing that you should do is to have an attorney prepare the will and have him be the witness. And that anytime that there's a will challenge, he would be the best witness to testify as far as your competency. The basis for setting aside your will is that you did not have the mental capacity to make a will. So certainly the lawyer would make that determination. The other one is undue influence. So if you want to leave most of your estate to one of your children and exclude some of the other or make a disproportionate share, then there's a couple of things that you need to try and do if possible, and that there's a presumption of undue influence if the person who that you're leaving these assets, a disproportionate share or all of your estate to them, whether it be a child or anyone else, did they select the attorney? Did they take you to the attorney's office? Were they present whenever you made out the will? Did they know what you put in the will? After you have the will, were they present whenever you signed the will? Did they know the contents of the will? And also as far as paying for it. So if some of these factors are present, it presents a undue influence. So if possible, not to have the person select the lawyer or take you to the appointment or know what's in the will. I realize many times that's not possible and that you're dependent on the caregiver or your child who's taking care of you to bring you to the appointment. And so I have over the years tried to do this as tactfully as possible, as tell the person that you're going to be living and that brought you there is they need to excuse themselves, wait in the waiting room, and I make a notation in my notes that I've excused them, and then discuss who you want to receive your estate and why you want to do that in order to try and overcome these problems in the event there is a will challenge after you're gone. Also, you need to put in the will, if you're leaving someone out, a child out, you need to just put in there expressly make no provision for a particular child to show that you did not forget them. The old thing of leaving them $1 is a terrible idea, and that you're tasked the lawyer with having to, or the executor, of trying to get them to receipt for $1, particularly if they don't like the provisions of the will. So just put in there that you didn't forget about them. You expressly make no provision for them. If you have any questions, give me a call at 727-847-2288.